St. Louis University Law School. He's our friend, and he's a KTRS Legal Analyst. Good morning, Greg Willard.
Good morning, McGraw.
All right, it has been a pretty crazy week when it comes to the Supreme Court. A couple of rulings. One was the travel ban, one was the abortion case, and the other one was the union case. Taking it as a whole, anything surprise you in these cases?
Not really, McGraw, because they indicate a lot of things, but the things about which they indicate are ones that we have observed for several years on the court, and those are specifically that the court ideologically is right on a razor's edge, in that you have four so-called liberal justices and four so-called conservative, and then on the edge, Anthony Kennedy.
Right.
And so with these decisions this week, we had a lot of 5-4 decisions on some of them, and then earlier in the month, Justice Kennedy wrote the opinion or was the fifth vote. So in terms of the outcome, not surprising. Rather, I think it just reinforced what a lot of observers have thought about the court for several years.
Yes, but all of these cases, Kennedy came down on the conservative side. And then the one case was the invasion of privacy, in which Justice Roberts switched the other side. Right.
And we can get to that in a moment in terms of Roberts' future role in the ideological balance of the court. But you're referring to the Carpenter case, which was the case out of Michigan, where the court, in a 5-4 opinion written by Justice Roberts, said that it is unconstitutional for law enforcement to access, in this case, 127 days of location information from our cell phones without a search warrant.
Right.
And Chief Justice Roberts and the four so-called liberals said that is unconstitutional and vacated Mr. Carpenter's 116-year sentence conviction.
Okay. All right, I'm going to set a little trap for you here. And let's talk about the Muslim ban for a second. Because the Supreme Court ruled this weekend, or this past week, that Donald Trump's Muslim ban is to stay. And it was a 5-4 decision, very contentious. Some called it a Muslim ban, some called it a travel ban. Donald Trump called it a Muslim ban. Sean Spicer called it a Muslim ban. They had to change it to make it legal, right? But it was still, it was originally a Muslim ban, struck down. This was, as you said, the third bite at the apple to create a constitutional Muslim ban in which the courts ultimately decided, yes, this Muslim ban is constitutional.
Yes, the court ruled 5-4 in another opinion authored by Chief Justice Roberts that the travel ban, some call it the Muslim ban, but the restrictions on the several countries was constitutional and was statutorily permitted. And Chief Justice Roberts went to great lengths to point out that if you look at the four corners of the document, it is almost identical, albeit even a little longer, than similar orders that presidents in the past have issued as to immigration with respect to certain countries.
Right.
Never challenged, never a problem. But in this case, for a variety of reasons, including some of the campaign rhetoric that then candidate Trump used, it became the so-called Muslim ban. I want to echo a point you just made a moment ago, McGraw, because I think I don't know that it's going to assuage our listeners who are so upset with the decision or with Donald Trump. But Donald Trump didn't get his way necessarily. As you said quite appropriately, the judiciary checked, in terms of checks and balances, checked him 3 times. And the travel ban had to go through 3 iterations before the judiciary said, okay, it's constitutional and statutorily permissible. So this idea that the 45th president is sort of running amok, unhinged, as his opponents would say, I would offer a slightly different perspective this morning. I think the judiciary did a whale of a good job as it constitutionally should, the last year and a half, in terms of going the extra mile to make sure that this order was constitutional.
Okay. In this decision, did they not say we need to read the document and not what Donald Trump said?
Yes. Chief Justice Roberts said that not only do we need to read the document, but we also need to look at the process that the executive branch went through in issuing this executive order. And again, process matters. And in this case, it went through 3 different iterations, and there were.
But ultimately, didn't they say, the majority say, hey, look, President Trump said this on the campaign trail, and President Trump said this at the podium, and this was the plan, and it was a Muslim ban, and even though it changed, and even though they skirted it, we have to take him at his word and what the document is and not necessarily what they say.
In effect, that's a fair summary. I think constitutionally what they said is when a president acts in this area of foreign affairs, he acts pretty much at the apex of his power. He has constitutional power over foreign affairs, and in this case, he has very significant statutory power. So what they are saying, and Chief Justice Roberts very pointedly said, given that power, it will take an extraordinarily high showing to overturn actions when he's exercising that power, and campaign rhetoric is not enough, McGraw.
Right, and so we have to take him at what the words are on the paper.
And the process.
Not what he said.
Absolutely.
And the criticism is, well, he wrote it in a way that made it legal, but basically what he wanted was a Muslim ban. And the court said, we don't care what he said, we only care what's on the written paper.
Well, what's on the written paper and the process that the executive branch used to issue that paper. And what the opponents say, you summarized it well, is, wait a second. His core campaign rhetoric permeates that document. You can't separate the two. This document was born coming down an escalator in New York City in 2015.
Yes.
And you can't separate the two, the opponents would say.
Now, let me bring you back to the Baker in Colorado, in which the Supreme Court said, hey, wait a minute. The Baker wasn't treated fairly because of the words that the Civil Rights Council said. But the words on the paper are wrong. So didn't they rule one way for the Baker and saying that the words matter and that he wasn't given, right, and he was treated unfairly, and even though they ruled on the letter of the law, they weren't given enough deference to the Baker and his philosophy and what, right? And so isn't it they ruled one way for the Baker and ruled the other way for the Muslims?
You are going to get an extra credit towards your law degree today, because that's a terrific analogy. I will agree with you in part, and then I'll give you an explanation in another part. In both decisions, sort of what went on outside the courtroom, what went on in terms of the travel ban or the Colorado Baker, that was at play. What the court said in a 7-2 decision, which Justice Kennedy wrote with the Colorado Baker, it said that the Colorado Human Rights Commission or Civil Rights Commission, their words, back to your comment, their words, their process was not appropriately deferential to the religious beliefs of the Baker. And therefore that process, not the decision, but that process was a 14th Amendment violation, and they sent it back to the Colorado Human Rights Commission for another decision. The difference between the travel ban case, in terms of words matter, and the Colorado Baker is this. In the Colorado Baker case, we're talking about the individual 14th Amendment rights of the Baker. And there's a whole separate set of constitutional principles as to how those individual rights are protected. With the travel, and those sets of criteria are affected by words outside or words as part of the process. With the president's travel ban, we are talking about the apex of presidential power. And what the court said in the travel ban case is words outside the process, or these words, are not enough to pull back on that apex presidential power, whereas in the Colorado Baker case, what Justice Kennedy said was the words and the process that the Colorado Human Rights Commission used created a process that unconstitutionally treated the Baker, and therefore we're going to send it back for further hearings out in Denver.
I don't know if I agree with that, but we will move on. No, that was my trap, right? That was a good question.
That was a great trap, and you would have been kindred spirits with the two dissenters that said.
I don't know that I didn't necessarily agree with my question, but the point is that it seemed like there was a double standard.
Well, it seemed like a double standard just on the question of words and words, but then when you look at the question the court had to decide in those two cases, you were one was orange and one was purple.
Well, that's the way you see it. We should say this: when was the last time a dissenter, Elena Kagan, read her dissent from the bench?
The reading of dissents, the reading of opinions are not unusual. When opinions are released, quite often the justices will read portions of their opinion. So, for example, in the landmark case U.S. v. Nixon over the tapes, Chief Justice Berger at the time came out and read substantial portions. What happened this week, particularly with the travel ban case and the union dues case, not only were several of the opinions read, but observers in the court commented on the emotional vigor, if you will, that several of the dissents, particularly in the union dues case, because of not only the substance of that case, McGraw, but it overruled 40 years of precedent, so what we lawyers call stare decisis. So the actual reading was not unusual, but the emotion that was in the courtroom was.
Elena Kagan's dissent on the travel ban was, you could read the anger coming from her pen.
It was, in an ironic way, it was very Scalia-esque. The late Justice Scalia, you could read his opinions and you could feel the emotion coming off the page. And I think her dissent in that case and others this week had a similar effect.
All right, I want to talk about the passing of or the stepping down of Kennedy here in a second. Can you hold on through the break?
Absolutely.
That's Greg Willard, who I almost got. I almost got him, but I didn't. I was close. Let's talk about